Good evening and welcome. This is the June 8th, 2022 meeting of the public hearing of the Land Use Commission. The City Code directs this body to hear applications for map and text amendments, special uses, including plan developments, zoning relief, and appeals from decisions of the zoning administrator, as well as to make recommendations regarding the city's long-term planning goals and objectives. Depending on the type of matter, this commission will either make a final determination or send its recommendation to City Council. Ms. Jones, would you please call the roll?
Commissioner Arevalo?
Here.
Commissioner Halleck? Commissioner Cullen? Commissioner Westerberg?
Here.
Commissioner Medinchev?
Here.
Commissioner Johnson? Here. Commissioner Linwall? Commissioner Hugo? Commissioner Pactel?
Here.
And Chair Rogers.
Here. With 6 members present this evening, did I count right? 6?
Yes.
We do have a quorum. Also present from city staff tonight are Neighborhood and Land Use Planner Megan Jones and Assistant City Attorney Alex Ruggie. Normally I have a long prepared speech, but I'm not going to go through that since we won't be hearing any cases this evening. We only have one item on the agenda, which is for 1571 Maple Avenue, 22 PLND 0032. And staff has requested that this item be continued until the June 22nd meeting. My understanding is they're still trying to get some information from the applicant. Is that correct?
Yeah, it's getting information from the applicant and cross-checking information with what we can get.
All right. So if anyone is here tonight because of that, we will not be hearing that case this evening. The first item we have on the agenda is the approval of our meeting minutes from May 25th, 2022. Has everyone had a chance to look through those, and is there a motion to approve?
Just one small correction.
Okay.
On page 6, the third paragraph under questions, it says Chair Scott then asked if it was Mr. Scott's contention. I think that should be Chair Rogers.
Any other issues to address? If not, is there a motion to approve the meetings from May 25th?
I'll move to approve.
Is there a second?
Second.
Been moved by Westerberg, seconded by Arevalo. We don't have anybody joining remotely, so we can just do a voice vote on this, correct?
Yes.
All those in favor say aye.
Aye.
Anyone opposed? And anyone not voting because they were not present at that time?
I wasn't present.
All right, thanks. Yeah, just so I have a vote of 5-0 to 1, and then that motion passes. As I said, the old business case that we have is the major adjustment to a plan development. The staff has asked for a continuance on that. Is there a motion to continue that until our June 22nd meeting?
I'll move to continue.
Been moved by Westerberg. Is there a second?
Second.
Second by Arevalo. Again, without anybody participating, we can do this by voice vote. All those in favor of continuing the case until June 22nd, please say aye.
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 Anyone opposed? By a 6-0 vote, the case will be continued until our June 22nd meeting. I do see that we have 2 people. I'm going to take things a little out of order here. We usually do public comment after communication and discussion, but I'm going to ask if there's anybody here who wants to make public comment so you don't have to sit through our training session. All right. So with that then, I will turn it over to Ms. Ruggie, who will be leading us through the training session this evening.
Good evening, Chair Rogers and members of the Land Use Commission. Alex Ruggie, Assistant City Attorney. Looks like this is going to be a quick night, and I will continue to keep this short so we can all go home. But this is just going to be a brief overview of some training. I know land use has been operating for a little while now, but it's just kind of an update to FOIA and OMA, how it applies to the land use, as well as Robert's Rules of Order. And then I'll do a little bit of training pertaining to the Land Use Commission specifically. So I'm sure you're all aware that the Open Meetings Act, or OMA as it's referred to, applies to all public bodies in the state of Illinois. You, as a commission of the city of Evanston, qualify as a public body. So that means that we have to operate within the confines of the Open Meetings Act. What does that mean? Basically, your meetings, such as tonight, have to be open to the public. They have to be noticed in advance. And then it has to be at a time and place convenient to the public, which is why you meet in here and not at Chair Rogers' house. Like I said, it covers all of the state of Illinois, the counties, townships, cities, and villages, and then commissions and committees of the city. The Open Meetings Act defines a public meeting as having a gathering with a majority of the quorum to discuss public business. So when you take those three things separately, a majority of quorum, tonight you have a majority of quorum, just barely. You're 10 members right now and you have 6 here, so that's a majority of quorum. And then discussing public business, which is what you've done here tonight. Like I said, the meetings have to be open to the public at a time and place that's convenient. And then this also applies to holidays. Unless a regularly scheduled meeting follows on holiday, you cannot hold a meeting on a holiday. The other part that I wanted to point out is that if a member of the public wishes to record the meetings, they may. A couple times, different public bodies within the state of Illinois have gotten a little caught because they accidentally had a meeting of a majority of the quorum and discussed public business, but it was outside of a formal meeting, and that would be a violation of the Open Meetings Act. So as the law department, we recommend that if there is a majority of quorum present, you ensure that no public business is being discussed. The other way in which OMA can be violated accidentally is via email. So if there's an email with a majority of the commissioners and public business is discussed, that could be a violation of OMA. I say could be because if you're just talking about meetings or scheduling, who can attend, who cannot attend, that's not really public business. It doesn't qualify. Attendance at meetings, the last 2 years, this has gotten a little different for everybody due to COVID. So pre-COVID, attendance at meetings in public was required, in person rather. Obviously during COVID, those restrictions were lifted, and we are still under a state of emergency by the governor of Illinois, so attendance via remote participation is still allowed. But once that state of emergency ends, the only time a commissioner can call in to add to quorum is if the rules specifically allow it, and if that commissioner is having a personal emergency or is out of town for work. Everyone's favorite, FOIA, Freedom of Information. So a quick overview, as a public body, we are also subject to the Freedom of Information Act. Freedom of Information Act basically instructs that all public documents are open to the public for inspection. It's to promote transparency within the government and the public, and we follow FOIA pretty strictly here. How does this apply to the Land Use Commission? Any communication submitted to the Land Use Commission regarding public business would be subject to FOIA. So I think at the last meeting, most of you heard me ask that if residents have communication for commissioners, it should go through the city. That way the city can maintain an adequate record for the public, and so that our records remain open to the public. This applies to all of you in a couple scenarios. If you had some emails, even on your personal account, that happen to deal with public business, they may be subject to FOIA. I say may because the courts are constantly updating this and disagreeing on what this means. So previously, it would have had to have been with a majority of the quorum or during your meeting. The courts have broadened that most recently to say, if you're a commissioner and you're talking about public business in your email, that would be subject to FOIA. If ever there's a FOIA request, you will most likely get an email from me telling you of the FOIA request and asking you to provide the city with any responsive documents you have. The other situation where this may occur is text messages. Again, they would have to be dealing with public business. And the courts previously said if it was with a majority of quorum, that would count. Or during the meeting, that would also count. So if you're texting someone about public business during the meeting, that would be open. Like I said, the courts have recently broadened that a little bit. We're going to continue to monitor, but I'd like you all just to be aware that your communication may be subject to FOIA. And last but not least for this set of slides is Robert's Rules of Order. You're all aware that the Land Use Commission has adopted its own rules and procedures for the meetings. Those govern your meetings. Where in which those rules perhaps may not have any specifics, then we would back up to Robert's Rules of Order. So why is Robert's Rules of Order and the land use rules important? It's important because here, when you're doing hearings and when you're making recommendations to City Council or final determinations, it's very important that you have a clear record in case it goes to circuit court or it's appealed. It's just very important that we have a clear record, and Robert's Rules of Order and your rules ensure that we do that. The most important part about Robert's Rules and making a clean record is to ensure that your motion is proper and receives a second. So just quickly going over a proper motion. It should include the case number, the location, and any conditions being set by the commission. So example, in the matter of case number 22 PLND 1234 regarding 567 Main Street, I move approval of the requested zoning relief with the following conditions, XYZ, and that the project be in substantial compliance with the testimony provided in the documents on file. Just so everyone's aware, saying I move what was previously said or so moved, they're not proper motions and they don't make for a clear record. Sometimes there's a lot of communication and discussion regarding what the motion is going to be. So if it's clear when the motion's made exactly the conditions that are being set, it just makes for a very clear record for us. I know I went through that quickly. If you have any questions, I provided my contact information, and Megan can provide a set of all these slides to everyone after the meeting. I believe all of you have completed the OMA training on the Illinois Attorney General's website, which is required of all commissioners, and provided a copy of that certification to Megan or Katie. If not, please go ahead and go to this website and do that. Once you've done it once, then you are good to go. All right, should we go to the next one? All right, the Land Use Commission. So, as you're all abundantly aware, you have standards for approval when you're reviewing a project. Just as a quick reminder, every standard needs to be met in order to approve the case. Also, a standard may be conditionally met. So this is when you place certain conditions on the property to ensure that the standards are met. Commissioners can have opposing findings on different individual standards, but like I said again, to make a clear record, they should be specifically stated. Any silence by a commissioner indicates agreement with the findings stated. Staff will always go through each standard and clearly address the standards in the memos provided to you for the cases. That way, the standards are at the forefront of the commission when we go through them, or when you all go through them. The findings and standards may change based on the testimony provided here at land use. And then it's okay to disagree with staff or other board members, but you must articulate a reason why there's a disagreement so that the record is clear. Obviously, the whole point is that 10 people should not always agree with each other. You should have differing views. Just be able to ensure that you put those differences on the record. Why do these standards matter? Well, they show that your determination regarding whether the zoning relief is approved or not is arbitrary or erroneous, which are reasons why your decisions could be overturned. If you have a clear record on why the standards are met or not met, then it's harder to overturn them. And that helps us if it ever goes to litigation or in any appeals. And obviously, as you know, your findings are given to the City Council for recommendation, and the clearer the record, the more the City Council can use those recommendations. This has come up many times. Some of the standards you are given are rather vague. I believe they are intentionally vague, but that's not really helpful sometimes when you're up here reviewing them. So an example of a standard I find to be vague: the requested variation will not have a substantial adverse impact on the use, enjoyment, or property values of adjoining properties. What's vague about this? Well, we don't define substantial adverse impact. What does that mean? My suggestion would be that the commission look to the word substantial when deciding if this standard is met, and be sure to articulate why or why not a substantial adverse impact exists. It's most important when you have vague standards like this to explain why you're finding something is a substantial adverse impact as opposed to just a minor adverse impact. And the clearer you can be in your findings, the less vague this is. The second example, the property owner would suffer a particular hardship or practical difficulty as distinguished from a mere inconvenience if the strict letter of the regulations were to be carried out. Again, there's several vague terms in here. How do you determine if something's a mere inconvenience versus a practical hardship? Well, I suggest looking at the keywords particular, practical, and mere, and how they kind of work together here. You can also consider the other standards required in this section. In this instance, the third standard states the alleged hardship or practical difficulty is peculiar to the property. So here, it would be interesting because I think if all the properties on that block had the same hardship, then you can say, well, it's not particular to this property. So then you can know that both of those standards are met. And then again, making the record clear and just, specifying why these standards are met or not met really helps going forward. Again, just to wrap up, if you do not see clearly how a standard is met, you can always ask the applicant. You can be direct about it. Don't bypass a standard. So I don't know that this standard is met, but I like the project. Well, we just can't do that. We have to follow the standards to make the record clear. Not all standards apply to every case, and I think we've seen that several times, even in the short time that I've staffed the commission. You can agree to disagree, like I said. Just make sure that the findings are on the record. And then this is important, that the land use only weigh the application and the testimony against the standards. So anything outside of the application and the testimony given really shouldn't be considered, because you need to use the facts contained within the record to make your determination. And then, like I said, all standards must be met to approve a project. So I did go through that rather quickly. Does anyone have any questions? All right, well, thank you so much. I appreciate it.
Thank you, Ms. Ruggie. And I'll just say that as the person who ends up going through the standards the most, I would appreciate if people don't agree with me. I usually at the end say, does everyone agree with my findings on the standards? And usually people do because I'm a brilliant person and always come up with the best answers. No, but most people agree with those. But if you do object to something, do voice it as we go through that standard, because again, to reiterate, that's important for the record. And if there is a standard that someone feels is not met, that a condition can be applied to in order to make it met, there may be other commissioners who are willing to go along with that proposal in order to get approval of a project or to at least make that standard met.
If people have disagreements about whether a standard is met, do you prefer people voice it at the time you're addressing that standard or at the end when you ask?
I prefer it be addressed at that time, because then if there's a condition about that one, while we're talking about that particular thing, it be addressed at that time. So if I say, the alleged hardship or practical difficulty is peculiar to the property, and I feel it is and state the reasons why, but you don't feel it is, that's the best time to have that conversation, not after I've finished running through the rest of them.
Matt, I do have a question. So like when we were on the zoning board, if you did not agree with one of the standards, then you had to vote
Yes,
no,
right.
just so everybody
Right,
understands
all
that.
standards have to be met, and if you think 6 of the 7 standards are met, and there's a way that you see because of some little change that could be made to the project to make all 7 met, in your opinion, do voice that, because if it's, I remember we had a case on Chicago Avenue where they were wanting to put balconies out over the right-of-way. And a couple of us on Plan Commission were like, okay, does anybody feel strongly that those must be there? Because there were a couple of us who did not want them there. And the decision was, well, nobody felt that they had to be there. It wasn't a strong feeling. So we asked for those to be removed as part of our approval. So that's how we got to approving that project by making all the standards met, because we didn't feel, a couple of us did not feel that one standard was met, but by removing it, nobody else had strong feelings to support it.
Yeah, but I was saying like, so when, let's say there's 6 of us here and there's a project and I don't agree with one standard.
Right.
Even if everybody else does, I would still be the opposing vote. So if it would be 5-1.
Right.
So whatever standard I do not understand or I do not agree with, that I have to vote no.
Right.
Okay.
And if you aren't quite sure what a standard means, because some of our standards are vague and weirdly worded, I know there's one, and I don't remember which standard it's in. It's in one of the Plan Commission standards, so I don't know if it was in that vague plan development statement that we used to have before we adopted standards. But one of them addressed the schools. And it's like, well, what does that mean? And it doesn't mean, is it going to affect the school buses that are coming to and from the school? It means if we approve a project that were to have suddenly 100 new students being shoved to Haven School, that's going to affect the school in some way outside of anything else. So it's something just to be cognizant of. I'm not saying that we would approve or disapprove based on that, but kind of making that, as we talk about that and make our recommendation to City Council, that they be aware of the possible impact of that sort of thing. And I'm happy to if you have questions about standards at any point, feel free to ask those as we run through the standards, because that's the time to do it and say, I'm not quite sure what this is or how this applies here. Because some of them do become rather vague, and they're worded vaguely for a purpose. Because if they were really specific, then projects would be killed left and right because they wouldn't meet the finite little details of a standard. Are there any other questions? Comments?
I think when you usually go through the standards after we deliberate, as I recall.
Yeah.
Do you want to do that beforehand, or do you want to hear
I
commissioners'
usually like to hear the
responses?
conversation because if discussion changes on a standard, like if I may think a standard is met, but I may see that 20 other, everybody else on the board doesn't feel it's met, I will address that a little differently when I get to it. Or if it's kind of a half and half situation, it's like, how can we get a majority of people to support that standard? Is there a condition that can be applied? Is it something as simple as moving the garage over a foot or something like that? So that's usually the way, and that's why that's why we usually do the motion afterward, so that we have all of that discussion out of the way, because otherwise we'd be constantly making little amendments to the main motion. And that gets very hard, again, for keeping that clear record of what it is that we're determining or recommending. And we are unique in the fact that City Council doesn't override decisions on which we are a determining body. So if someone doesn't agree with the decision that's made, it goes to the courts. And the courts want to see that record, which is why we go through the standards in detail. So there's, again, is a record of that discussion. And that's also why it's important that if you do not agree with the majority on the standards, that you voice that opinion, because if we run through the standards and somebody doesn't say anything the entire time, and then all of a sudden they are the one no vote, or they're the vote that denies a project, the applicant doesn't really have an understanding as to why. And the courts, if it goes into the courts, would not necessarily understand why and could say it's an arbitrary decision. There was no discussion. That particular commissioner did not make a statement, did not address the issue. They just voted no. So it's an arbitrary statement or an arbitrary decision. Anything else?
Now, how do we take into account, like, the verbiage of particular hardship or mere inconvenience? Because everybody obviously will fight for their point of view.
I think that's one of those things, because when I was on ZBA, the one that we used to have a lot of difficulty with was the minimum change necessary. Well, what is the minimum change necessary? I want to put a two-car garage in. Is a two-car garage 20 foot by 20 foot? Is it 20 foot by 22 foot? Is it 22 foot by 24 foot? What's the minimum? And everybody has a different answer to that. So I think part of that is being able to articulate why you feel strongly on something. So if you feel that it is a real hardship versus an inconvenience, or vice versa, being able to articulate why that's the case. So, on this particular block, we see 6 houses that have the exact same setup. None of them have this problem. So how did they address it? And is there a way we can address it in that same way?
Okay, but then that goes back to, are we using precedent to?
We don't use precedent. There is no precedent, because for any property that you can bring me, I can point out one thing that's different on it. So just because somebody has a swing set or has a garage or has whatever, doesn't mean every property gets that same setup, because that garage may be shifted a foot closer. It may be that they had to move it because of a tree. There's always some strange little factor in it. So there is no precedent per se. We try to be consistent in the application, but there really isn't a precedent as such.
Well, like you were saying, so if there's, let's say everybody's fence line is here, and I want to move mine 1 foot over, closer to, do we keep it just because everybody else is there? Or if I argue my case well enough, will I get my 1 foot?
If there's a reason if you can make a compelling argument for why that 1 foot is necessary for you, we do look at, in that particular situation, we look at things like, we have the 27-foot front yard, but that becomes irrelevant if everybody has a 15-foot front yard, or people have a 12-foot front yard and an 8-foot front yard and a 7-foot front yard and a 12-foot front yard. So it sort of becomes a consistency thing across that too. So there's a bunch of balancing of different things, and it's up to an applicant to make their argument.
And that's usually the way I see the cases anyway.
Right.
You know, if they make the compelling argument and it makes sense, then I would vote yes for that project. I don't go by, well, my neighbor has this, or, you know,
Right.
I've seen it down the street and I've seen it in other places, and, you know, why did they get and I don't get kind of situation. And that's why I'm saying it's the particular hardship versus a mere inconvenience. If you argue hard enough, you will get your mere, you know, your particular hardship versus a mere inconvenience.
Right, I mean, it's up to the applicant to explain to us why it is a hardship for them. Some of them are pretty straightforward and easy to identify, and others are more difficult. Some of it, I mean, we've had applicants who have said, well, I want it here. And it's like, well, that's not a compelling argument for you. You know, just because you want something doesn't mean that's what it is. We apply the standards, and we should be applying those as equitable as we can across all properties. And we should use the exact same logic in if somebody wants something and all of their neighbors are opposed to it, that doesn't necessarily mean that we shouldn't grant it. Because if it were all based on popularity, then we wouldn't need to be here. The neighbors would all just get together and take a vote, and whatever they decided would be the decision. So we have to listen to the public, but not just always vote because the public says something is the way they want it to be. That's the way it has to be. Anyone else? Anything? Anything you'd like to add, to respond to anything I said where I maybe said something I shouldn't have?
No, I'm glad that there was some discussion. I think that even though the Land Use Commission has been meeting for a while, it's just good to have these open conversations to discuss this, because I think for everyone it is a little bit of a learning curve, and I appreciate the questions. If there's more questions, like Chair Rogers said, you can reach out to him about standards. You're always welcome to contact the law department if you have questions about standards before meetings, after meetings. The law department's in-house, so we are here to support the commission. And just appreciate your time tonight. Thank you.
Thank you. Ms. Jones, do you have anything else to bring before the board tonight?
I do not.
All right. With that, I'll entertain a motion to adjourn.
I'll move to adjourn.
Moved by Westerberg. Is there a second?
Second.
Seconded by Putel. All those in favor, please say aye.
Aye.
We stand adjourned until our next meeting, which will be on the 22nd
Correct.
of this month. Thank you.